Hi everyone, my name's Hickman. I'm an associate solicitor in the immigration team at Bindmans, and I'm here with the third edition of our podcast, Immigration Unpacked, where we're talking about all things immigration and citizenship related. Today, I'm talking to my colleague, Roberta Haslam, who's a partner in our team, and we are going to be talking about how the government has introduced some changes that will make it easier to refuse certain people who are applying for partner visas. So the section that we're talking about is part suitability, it's called, and it's a whole new section that's been inserted into the immigration rules and went live on the 11th of November. And that section covers the reasons that the government can use to refuse visa applications of any type. So for lots of visa categories, this new section isn't really going to make a huge difference. It's just kind of a bit of rewording, rebranding, relabeling. But for certain people, the changes are going to be bigger. That's going to be people in human rights-based categories, such as those applying on the basis of a relationship with a partner or the amount of time they've lived in the UK. And the reason this is going to make such a big difference for these people is because until now, they had their own kind of separate refusal grounds and were generally treated more generously. But now what the government's done is they're lumping everyone together in one big section and saying it doesn't matter really the basis of why you're here, you're all going to be refused for the same reasons. Part suitability is big, and we can't possibly go into it in any kind of huge detail for the purposes of this podcast, but it's an issue that Roberta and I have been talking about quite a bit over the last couple of weeks. And we've noticed that for people on partner visas in particular, we think there are some big changes in store. And we've kind of identified two key areas where this part suitability is going to make a difference. So the first key area is overstaying, and the second key area is convictions, what that means for people with convictions. So Roberta, could you kind of tell us a bit about the overstaying provisions, like what this change means for people applying for partner visas, kind of what was the situation before and what's changed since before?
Okay, yeah. So before the 11th of November, when these changes came in, if a person had overstayed and then left the UK to apply as a partner, it wouldn't automatically lead to a refusal. So if they'd kind of had a long overstay and then decided to leave the UK and come back and apply for that visa, it wouldn't be a bar to them succeeding in a successful application. And we often advise people to leave the UK even if they had a significant overstay, because it could be beneficial for them.
Like,
yeah.
What, really? I can just leave it? But that we get asked that so much. It won't be a problem coming back in. And we're like, well, no, not really. Yeah, sorry, go on.
Yeah, no, exactly. And the benefit for people was that if they left, then they could meet all the main requirements and they'd be on a 5-year route to indefinite leave to remain, and they didn't have to show the kind of very exceptional circumstances and quite a significantly higher threshold, as you know, if you had to apply from in the UK as an overstayer. So it could be a beneficial thing for people to leave, and it was really only if there were other kind of really aggravating factors, so that overstay in it would cause a problem.
Yeah.
This has changed from 11th of November, like you said, so it's brought it in line with other categories like people coming to study or work. And now the Home Office's new position under this part suitability is that if someone has overstayed for more than 30 days, their application must be refused for 12 months. So that's a long period, and it's really going to affect people quite significantly. It could be more than 12 months, depending on how they left the UK. So if the Home Office or the government kind of public purse paid for their removal, it could be longer, from 2 years to 10 years, depending on how that removal happened. So it is really significant, and it will, cause real gap, wait for people if they decide to leave for that 12-month period. And these are family members. These are kind of people who are coming to join their partners, who may have children who had established lives here. And I think, it's going to cause a big change in the landscape, and it can't be underestimated, really.
Yeah, I was really shocked when I saw it. I remember emailing you and being like, oh my God, does this mean what I think it means? So someone who's living here just quietly below the radar, going about their lives, they want to kind of regularize their status and be on the 5-year route, they've got to leave the country for a year before they can come back in. That's basically what it says.
Exactly.
And at least a year, as you said.
At least a year,
depends on how they've ended up leaving. So that's the first main area, really. Overstaying is just an overview. And the second main area is convictions. And so for people who don't know, it's helpful to understand that the Home Office has what's called mandatory grounds for refusing an application. That means that the Home Office, like caseworkers, have to refuse the application. And then they've also got something called discretionary grounds, where the caseworkers may or should generally refuse an application, but it will depend on the circumstances. And prior to the 11th of November, there was a lot more discretion. So for some cases, again, we're talking about partner visas here. It's actually when you had a sentence, or when you had a sentence, a prison sentence of 4 years or more, that they were always going to refuse you. But there was a lot more discretion depending on the kind of visa you were applying, the length of the sentence, and when it had ended. So, for example, with sentences of 1 to 4 years, if it was a first-time partner application or an extension, it was only mandatory to refuse the application if the sentence had ended within the last 10 years. So if it had been more than 10 years ago, the Home Office would often approve the application. If it was a sentence of less than 12 months, so if someone had been convicted and sentenced to less than 12 months, it kind of scaled. If it was a first time or extension application, then you had to wait 5 years before you could apply. If you were applying for indefinite leave on the 5-year route, then it was mandatory if the sentence had ended in the last 7 years. If it was indefinite leave on the 10-year route, it was mandatory in the last 10 years. So there was all these little slightly varying ways it could happen. But generally, barring a sentence of more than 4 years, if you waited a certain amount of time, then you weren't going to be automatically penalised. Like, there was still a way to make the application, but how long you would have to wait would vary. But now, Roberta, that's changed. So from November 11th, everything's got much harder. So can you kind of outline for us what the situation is now for people applying on partner visas where they've had a conviction?
Sure. So, I mean, the key change is the matter of passage of time is no longer going to apply. So if someone has received a custodial sentence of 12 months or more, no matter how long ago it was, an application must be refused, and that's for entry clearance or permission, so kind of in-country applications. And that's a mandatory refusal. Permanently.
Forever. Regardless of the length of the sentence.
Exactly. Well, as long as it's 12 months or more.
12 months or more. So there's no longer this division between 12 months, 4 years.
4 years, exactly. That's gone.
If it happened in the 1970s, that's it.
Exactly. Okay. And that, so that's very significant, especially if, exactly you say, it was 20, 30 years ago, someone's turned their lives around. That's, on the face of rules, is a mandatory refusal. Applications must also be refused if someone's considered to be a persistent offender who shows a particular disregard for the law, or if they have committed an offence which has caused serious harm. So this persistent offenders, it tends to be when it can be much more kind of minor sentences or offences, but you have a number of offences that have happened over a short period, which therefore shows they think, or the Home Office say, well, that person's not paying attention to our rules and requirements, or that shows that they disregard the law, they should be refused, they must be refused. There's a discretionary refusal, so may be refused if a custodial sentence is less than 12 months, or if someone has a criminal offence and they didn't receive a custodial sentence, or there's been an out of court disposal, which is recorded on their criminal record. So other kind of fines or penalties that might show on someone's criminal record. It's a discretionary reason for refusal now. It's not a must, but again, it's a may. And again, time doesn't matter. It doesn't matter how long ago it was. So it's harder to kind of be clear, for people to be clear what the impact is going to be. How are the Home Office going to look at it, and how is this going to be interpreted? And I mean, that creates a lot of uncertainty for people, I think, and certainly people need to be making representations about that.
Yeah, so saying why, even though crazy, I don't know, they got a conviction for speeding 5 years ago, they can't assume anymore, because it used to be you waited 2 years, and now they can't assume that the Home Office is going to overlook it, and arguments have to be made as to why the Home Office should disregard
Exactly. So the Home Office have guidance about how caseworkers can look
Right.
at this, and things they'll take into factors are like what the offence was, how long ago it was, how long ago it took place, has there been a change in that person's circumstances? So, was there a particular issue that was in their place at the time that kind of potentially contributed to that offending behaviour? That can you argue that that's really changed now? But these are, they are things that need to be looked at and explored and put to the Home Office. And each case will need to be looked at in their individual facts. And I think we'll have to see how the Home Office apply these kind of going forward in family-based applications.
I think for me, like where there's discretionary grounds for refusal, I think it's horrible, but at least it's still arguable. Some of the stuff that really shocks me is some of the mandatory grounds where you have to refuse. And I think it's worth flagging up here that that there's, even though these are human rights cases, and even though you're talking about separating families, that where anyone has ever had, they've got a special section of the rules that says, even though the rest of the rules say this, if there are exceptional circumstances that that means refusing would result in unjustifiably harsh consequences for the applicant, their partner, or a child, you might be able to argue that the government should ignore, that the Home Office should ignore some of the grounds for refusal. But actually, the government has expressly said that it doesn't care. So where you have had a sentence of a year or more, there is no wriggle room. There's no way to argue that this would have a terrible impact on a child. So you could have a situation where, someone's lived in the, we can all think of situations. I probably shouldn't start listing off examples, but you can see how it would be that like families would literally be split, and there's no way to argue that the immigration rules should be ignored. And one of the things that I think we haven't really quite got to grips with is what effect this will have on people who are already here. So what if someone had, a conviction, I don't know, had this a speeding conviction 10 years ago, or worse, had a custodial sentence 20 years ago for something, they got 12 months, and they, under the old rules, they're here, they're living here, they're working, they've moved here, and now suddenly when they come to renew their visa, like what do we think is going to happen? I mean, because there's no transitional.
No, I was going to say there's no transition. Sometimes when there's a change in the rules, people who are already on a route, the old rules carry on applying for them. But as we've discussed, I can't see that applies in this case. These new rules are going to apply when people make new applications, and the rules and the guidance aren't really clear about how the Home Office are going to treat them. What if someone's previously been granted leave in knowledge of this? Should that not, I would think, be quite a proportionate or quite a big factor about why it shouldn't be held against them now? But I think it's really going to be a waiting game to see how these do apply to people in these applications in the future. And I would hope that they take a proportionate approach and recognise people's lives. But this is a real shift in the Home Office's kind of attitude to these applications, and they deliberately applied it to this category. So I think it's going to be, we're going to have to wait and see and try it out and test it and see what happens for people. But it is concerning. So yes, this is going to apply for people in future applications, even if they're already here and were fine before. And that's, it's very unsettling for people and worrying.
And is there anything else you think about these changes, Roberta, that people need to be aware of? I think we flagged up two big areas, but is there anything else that you think?
I kind of think, I mean, there are lots of bits and changes throughout the kind of suitability things. I think people just and really need to be aware of this. If someone is overstayed, just thinking about what we're focused on, but if it's a very recent overstay and you're thinking of leaving to make an application, make sure you leave within the 30 days after you've overstayed, because you could avoid the bans in that way. So kind of act promptly. I think you really want to be thinking about the situation and making sure you make clear in applications the history, the context. But it is a time when the Home Office are tightening their approach. Issues are being it is getting harder, and people need to kind of be prepared and set out their cases as strongly as possible. I think something we haven't talked about so much today actually is applications of people with leave can also have their leave cancelled on the same basis of these criminality provisions that we spoke about earlier. So if someone's had a 12-month sentence, and I think it's a mandatory cancellation ground for their permission now as well. So, you know, I think the more that people can reach indefinitely to remain and look at citizenship as well, if they can get there, it's really worth considering to kind of get yourself in a secure position.
If you can.
If you can. I mean, obviously it will depend on if you've got convictions, that's well going to impact on a citizenship application, and or you may not be kind of yet in that position anyway.
Yeah, it's like you say, it's just worrying times really, and yeah, I don't think we have any amazing like solutions. Just yeah, kind of be careful, do what you can, be prepared, understand that the situation's changing and the landscape in general is changing, and it's negative times. Yeah, I'm sorry to finish on such a dark note.
I mean, it may be that we see some of these discretionary applications when there's been historic grants, you know, that the Home Office have more take that into account, and that will come out to see. And I think it really is probably a matter of watching this space, so to try and not to lose all hope, but kind of see some positivity, you know, hope forward. But we just have to see how things are. It's such a recent change.
That actually, where someone has lived here for, you know, 4 years, has quit their job, an offence was, I don't know, 20 years ago, and the Home Office has allowed them through twice, like first aid extension. I mean, the Home Office might refuse them, but I can see that's going to lead to a lot of challenges. You know, based on what people were entitled to expect, and having the rug pulled out from under them. But anyway, like you said,
absolutely agree. Definitely.
Okay. And on that somber, slightly less dark note, we're finished. We'll be back in another few weeks to discuss another issue. And that's it for now from me and Roberta. Thank you.
Thank you.